Hi, I'm attorney John Mangan, and in my approximately 15 years of practicing law, specifically in the area of trusts and estates, I've had the opportunity to work with a lot of clients and their families to help probate and administer the estate of their loved ones. So today we're doing another installment of our series all about the probate process. And what we're going to focus on today is the priority in terms of payment for creditor claims. So you may recall from a prior video that we did, whenever we have a probate estate open, there's always an opportunity for creditors to file a claim against the estate. And assuming that the claim is legitimate, then at the end of the day, once the creditor claims period has run, there are some decisions that need to be made by the personal representative in terms of who gets paid and in what order. So in the vast majority of estates, there are sufficient assets to pay all of the creditor claims. But occasionally we do run across an estate where we just don't have a lot of assets, or maybe there are some very significant claims. So there's an imbalance. We have a greater amount of claims than we do assets. The other factor that can trigger this type of a situation to occur is when we have some substantial assets, but they are considered exempt. And we'll talk a little further about that in a minute. And there are really 8 classes under our Florida probate code. And if you like, you're welcome to go look them up. You can find them in Chapter 733. I'm not going to go through all 8 classes, but let me just hit a few of the highlights. So Class 1, meaning these are the first claims that get paid. These are things like the costs of administration. So when the personal representative needs to pay a court filing fee, or needs to pay for an appraisal, needs to pay to publish a notice to creditor, all of those things are costs of administration, and those fall into Class 1. Other examples of Class 1 payments would be things like attorney's fees, compensation for the personal representative. Those are your main components of the Class 1 claims. Now, next is Class 2. And Class 2 covers reasonable funeral, burial, and cremation expenses not to exceed $6,000. So those final expenses up to the amount of $6,000 all fall into Class 2. To the extent that those might exceed $6,000, then they're going to fall further down the pecking order. Another thing I'll hit on here comes in Class 4. Class 4 has to do with the medical expenses of the last 60 days of the last illness of our decedent. So these are often hospital bills, doctor bills, diagnostics, things of that nature. Class 6 covers unpaid court-ordered child support. Now, I think you heard me say court-ordered. So as long as there was a court order, and if the child support was not paid, then those claims will fall into Class 6. Class 8, which is the last of our 8 classes, really is a catch-all, and that covers everything else. What I see frequently fall into Class 8 will be unsecured credit lines, credit cards, things like that. Maybe it's credit that was obtained from a store to purchase some items, and that amount had not been paid back yet. So that's just kind of a quick overview of the 8 classes. And in terms of order of priority, Class 1 gets paid first, then Class 2, Class 3, so on and so forth. And if at some point we no longer have sufficient assets to pay all of the claims, then those that fall further down on the list are just not going to get paid, or at least not in full. Now, I mentioned at the beginning of this video that there are some assets that might be determined to be exempt. And if they are exempt, then claims cannot attach to those assets. The big one here in Florida has to do with homestead property. So homestead is the primary residence of somebody who's domiciled here in the state of Florida. And there are also some acreage limitations that we find in our Florida Constitution. So for example, if the property is located inside of a municipality, then the exemption extends up to 1/2 of an acre. If the property is outside of a municipality, then it extends up to 160 acres. The other important part about homestead is to whom is it being left? If the homestead property is left to someone who would fall under the category of heirs at law under our probate code, and these are just about any family relationship that might come to mind, whether it's ancestors, parents, grandparents, etc., or descendants, children, grandchildren, great-grandchildren, even nieces and nephews and cousins and uncles and aunts, they're all going to be heirs at law. So if the person that's receiving the homestead is one of these heirs, then the property can likely be determined to be exempt, but it does require a court order. Another example of some assets that may be determined to be exempt and therefore untouchable by creditor claims would be personal property, up to $20,000 worth for things like household furnishings and appliances. In addition, up to 2 automobiles, and there are some weight limitations. We're not talking about semi-trucks or anything like that, but generally up to 2 automobiles may be determined to be exempt from creditor claims. Okay, so one final point that I want to mention on this whole idea of the priority of creditor claims in a probate estate. We talked a bit earlier about there are situations where maybe we don't have enough liquidity, enough assets, at least of the non-exempt variety, to satisfy creditor claims. Well, it's important to understand that there is a section under our probate code and our trust code that says that if the decedent had a trust that was revocable, meaning they could change it right up until the moment of their death, at which point it became irrevocable, then the assets in that trust are considered available to satisfy creditor claims. So just to give you an illustration here, let's say you have creditor claims in a probate estate that total $100,000, and you've only got $50,000 of non-exempt assets in that probate estate. We also have a trust that was revocable up until death that the decedent owned, and you've got $1 million worth of assets in that trust. Well, so we've got a shortfall of $50,000 in the probate estate, and that trust then would be required and expected to make up that shortfall and pay the $50,000 into the probate estate so that all the creditors are satisfied in full. So I know I just threw a lot of information at you all about how creditors get paid in a probate estate. If you have any questions that are specific to your situation, please feel free to reach out to us. We're here to help.